In today's video, we will answer a recent question from one of our viewers. What is a writ of habeas corpus, and how can it be used to help a person who is confined or restrained by an agency of the government? The answer to that question is coming right up. Welcome to Gustitislaw. If this is your first visit here, I'm Steve Gustitis, and this is my channel. Our passion here at Gustitislaw is to provide you with weekly videos about how to effectively navigate the criminal justice system, how to defend criminal charges, and how to manage encounters that you may have with the police. If you subscribe to Gustitislaw and click on the bell, you'll receive notifications whenever we upload a new video. And I also enjoy answering your questions and responding to your comments, so add those down in the comment section below. Habeas corpus is what's called an extraordinary remedy and used to challenge the lawfulness of a person's confinement or their restraint. Habeas corpus is essentially a command from a court with proper jurisdiction to anyone who has a person under confinement or under restraint. The writ of habeas corpus applies to all confinement that is applied without lawful right or that is applied in an unapproved manner or degree. Importantly, the terms confinement and restraint are interpreted broadly when talking about habeas corpus. A few examples will help illustrate that concept. Example number 1. A person who is in jail, unable to make bond pre-trial, is a person confined or restrained. Example number 2, a person who has made bail pre-trial, but is subject to court-ordered bond conditions like curfew or driving restrictions. That person is also confined or restrained in their liberty. A third example of a person who is confined or restrained is a person who has pled guilty pursuant to a plea bargain and has received a suspended sentence of probation subject to court-ordered conditions. That person is under restraint. And of course, a fourth example is a person who is convicted after trial and is serving prison time. Of course, that person is confined in their liberty as well. Consequently, whenever the restraint or confinement is illegal or done in an unapproved manner, the person who is restrained can challenge that restraint using the writ. Writs of habeas corpus are broken down into two general categories. Number 1 are pretrial writs, and number 2 are post-conviction writs. Let's take a look first at the pretrial writs of habeas corpus. A pretrial writ can be used to obtain a bond or a reduction of bond after a person is confined in jail following an arrest pre-trial. If the offense for which the person was arrested is bailable under state law, the person can use the writ of habeas corpus to get a court hearing and get review of either the amount of the bond or the failure of the court to set a bond. Another example of the use of a pretrial writ of habeas corpus is after a person has been arrested, they've made bail and now been released from jail pending trial, but they are now subject to court-ordered conditions of bond, like a curfew or driving restrictions or random urine testing and things of that nature. Sometimes bond conditions are reasonable and sometimes they are not. But a person can use the pretrial writ to challenge those conditions of bond in an attempt to get the judge to modify, change, or even eliminate unreasonable bond conditions that are applied in that person's particular situation. Let's take a look now at a couple examples of post-conviction writs of habeas corpus. In post-conviction writs of habeas corpus, the person confined or restrained typically must prove that their restraint was caused by some violation of either their federal or state constitutional rights. Using the example earlier of the person who pled guilty pursuant to a plea bargain and received probation as a suspended sentence, if that person's guilty plea was not voluntarily made, they could challenge the confinement or restraint using the post-conviction writ. Mistakes by the court, a prosecutor who failed to abide by the plea bargain agreement are just some examples of how a plea could not be voluntarily made. Since voluntariness is a constitutional due process claim, it can be challenged through the post-conviction writ of habeas corpus. In our example of the person who was serving prison time following a trial where they were convicted and sentenced, if that person's lawyer provided them ineffective assistance of counsel, that person could potentially challenge their confinement using the post-conviction writ, since effective assistance of counsel is guaranteed by the Sixth Amendment to the United States Constitution. These were just a few of the ways that a writ of habeas corpus can be used to challenge a person's illegal confinement or restraint. There are many, many more. If you have a question about a case that you are personally involved in, I would recommend that you contact a qualified criminal defense attorney in the state in which the confinement is occurring to get a consultation about the facts and the law that might apply to your case. If you have any questions, if you have any comments about today's video or the writ, add those down in the comment section below and I'll be happy to respond to those. Give us a thumbs up if you liked the video today, and don't forget to share it on your social media platforms. Thank you for watching.